The marble columns of the Supreme Court gleamed under the soft wash of morning sunlight as it streamed through the towering windows. Inside, the nation's highest tribunal convened for Wilson versus Educational Opportunity Foundation, a case destined to test the meaning of equal access to education across America's diverse communities. Most analysts expected an intellectually rigorous yet routine session, dense with debates over funding formulas, statutory interpretation, and jurisdictional nuance. Chief Justice John Roberts, seated at the center of the bench, presided with his trademark calm and composure. At 70, he carried decades of judicial experience and an enduring reputation for his disciplined intellect and balanced approach, even among ideological opponents. Among those scheduled to speak was Representative Jasmine Crockett, a former civil rights attorney who had submitted an amicus brief and received permission to argue before the court. Though respected in legal circles, few anticipated that her presence would command the room. Yet what transpired next would leave every person in that chamber silent. As Crockett concluded her meticulous, eloquent argument on educational fairness and constitutional duty, Chief Justice Roberts leaned slightly forward. Instead of immediately inviting questions, he paused, an uncommon gesture in that solemn space. His voice, steady yet weighted with sincerity, broke the quiet. "Representative Crockett," he said, "before we proceed, I wish to acknowledge something. In all my years on this court, I have rarely witnessed legal reasoning that weaves constitutional principle, precedent, and real-world impact so seamlessly. Your advocacy this morning reflects the very essence of legal excellence." The chamber froze. The emotion behind his words was unmistakable. This was not perfunctory courtesy, but genuine respect. In that instant, every person present, justices, clerks, reporters, and onlookers, understood that they had witnessed something extraordinary, a moment where intellect and integrity transcended the boundaries of partisanship. Before we continue this remarkable story, please take a moment to like this video and subscribe to our channel for more powerful stories of legal mastery, integrity, and leadership beyond politics. To grasp why this exchange between Chief Justice Roberts and Congresswoman Jasmine Crockett resonated so deeply, one must look at the two figures themselves. Roberts had long been regarded as a paragon of discipline and judicial craftsmanship. A Harvard Law School graduate and managing editor of the Harvard Law Review, he clerked for then-Justice William Rehnquist before rising through the Department of Justice and private practice. Having argued 39 cases before the Supreme Court, his elevation to Chief Justice in 2005 solidified his image as a jurist who balanced reverence for tradition with openness to constitutional evolution, though often aligned with conservative reasoning. Roberts occasionally defied expectation when constitutional fidelity demanded it. Colleagues and scholars alike noted his unwavering belief that the court's legitimacy depended on impartial guardianship of principle rather than political influence. As one former clerk famously remarked, "The chief believes that the court must remain the nation's compass for constitutional truth, not a reflection of its political storms." In this context, his rare and public recognition of Crockett's advocacy carried exceptional significance. Jasmine Crockett's path to that moment had been very different, but equally profound. After law school, she devoted her career to representing marginalized communities in civil rights and education cases. While many of her peers pursued lucrative careers in corporate law, she chose to stand with those whose futures depended on fair opportunity. Her understanding of constitutional law was not merely theoretical. It was forged through lived experience. Through classrooms underfunded and communities overlooked, her advocacy combined rigorous logic with human empathy, bridging doctrine and reality. That same approach had earned her landmark victories before she entered Congress, where her legal expertise continued to shape her policymaking. Now, in the Wilson case, she faced a defining challenge, determining whether funding disparities among school districts violated the Equal Protection Clause. The stakes could not have been higher. Questions of local control, federal duty, and the fundamental promise of equality had divided courts and lawmakers for generations. If you've ever witnessed a moment where professional respect rose above division, share your reflections in the comments below. Moments like this remind us that authentic expertise and integrity can still bridge even the deepest divides. That morning, beneath the intricate ceiling of the Supreme Court, the atmosphere was charged with solemn expectation. The marshal's formal announcement echoed, and the 9 justices took their seats. After a brief series of procedural matters, the court turned to the day's main case. Counsel for the petitioners opened with a capable argument defending traditional funding systems and local autonomy, skillfully answering a volley of questions. But when Representative Jasmine Crockett approached the lectern, the tone of the room shifted almost immediately. From her very first words, it was clear that this would be no ordinary presentation. "Mr. Chief Justice, and may it please the court," she began with deliberate calm. "This case confronts a central question in our democracy: how we interpret equal protection when access to quality education, the foundation of citizenship itself, varies so drastically by geography and income." Her voice carried confidence without force, authority without arrogance. Crockett's argument unfolded like a symphony, layered, disciplined, and anchored in precision. She traced the evolution of equal protection jurisprudence, referencing pivotal rulings that had shaped the court's view of education over the decades. Unlike many advocates who selectively quote precedent, she engaged directly with cases that might have undermined her stance, dismantling their limitations with respect and clarity. In San Antonio versus Rodriguez, she noted, this court held that education is not a constitutionally recognized fundamental right. Yet in Plyler versus Doe, the court reaffirmed that education is essential to preserving the social fabric and enabling citizens to exercise other rights meaningfully. That intellectual honesty captured the justices' attention. Even the most reserved among them leaned forward. Then came the first probing question, from Justice Elena Kagan. "Counselor," she asked, "if we adopt your framework for evaluating these disparities, what stops similar challenges to other locally funded public services?" Crockett didn't flinch. "Justice Kagan," she replied evenly, "education stands apart because it empowers the exercise of every other constitutional right. The limiting principle flows from this court's own precedents, which recognize schooling as the foundation of democratic participation." She then outlined a careful 3-part test, drawing from precedent, showing how courts could separate educational equality from other policy debates while maintaining respect for federalism and separation of powers. A moment later, Justice Samuel Alito pressed from another angle. "Your argument implies deep judicial oversight of local education funding. How does that align with our respect for state autonomy?" Crockett's answer came measured and precise. "Justice Alito, federalism protects both state authority and individual rights. The model I propose allows local discretion in education while ensuring that extreme inequities, when proven to undermine equal protection, remain subject to federal scrutiny. The two principles, autonomy and equality, need not conflict." Her composure and depth silenced the usual ideological tension. Even the skeptical justices seemed to acknowledge the intellectual integrity of her reasoning. As her argument advanced, Crockett pivoted to her third major point, empirical proof. Rather than rely on lofty rhetoric, she introduced hard data connecting school resources to measurable outcomes, anticipating potential counter-arguments with precision. "Empirical evidence confirms what this court recognized in Brown versus Board of Education," she stated, her tone steady. "Inequality in resources inevitably translates to inequality in opportunity." Her presentation bridged law, logic, and lived reality, a fusion few advocates achieve before the nation's highest court. And in that moment, the marble chamber wasn't just a courtroom. It was the stage where evidence, intellect, and moral conviction converged to remind a divided nation what justice could still look like. "Board of Education," she said, "education must be made available to all on equal terms if equal protection is to have real meaning rather than symbolic form." Modern longitudinal studies demonstrate that persistent funding disparities create exactly the type of arbitrary disadvantages the 14th Amendment was meant to prevent Chief Justice Roberts, who had listened intently, finally asked what many considered the most difficult question. "Representative Crockett," he said, "your argument asks us to make comparative judgments about educational adequacy. Doesn't that risk drawing the judiciary into policy decisions that should belong to legislatures?" The room grew especially still. This was a defining moment. Crockett's answer combined humility with firm constitutional reasoning. "Mr. Chief Justice," she began the framework. "One proposed fully respects the legislature's primary role in shaping education policy while preserving this court's essential duty to enforce constitutional guarantees." Her response showed deep respect for judicial restraint, yet firmly reminded the court of its responsibility to protect fundamental rights. She continued her explanation with remarkable specificity, connecting every constitutional principle to both historical context and the lived reality of unequal opportunity, the very intersection that made her advocacy so compelling. Crockett explained that the test she proposed would not require the court to decide education policies or set funding levels. Instead, it would ask a narrower and more constitutional question whether funding disparities become so extreme that they effectively deny some children the basic education necessary to exercise their other rights and participate fully as citizens. From there, she linked her reasoning to the court's own institutional traditions. "This approach," she said, "builds on the court's long-standing practice of defining constitutional floors without imposing policy ceilings, protecting legislative flexibility while upholding the Constitution's guarantees." Throughout her presentation, what truly set Representative Jasmine Crockett apart was her composure under pressure. She treated the justice's toughest questions not as threats, but as opportunities to deepen her argument, each answer built naturally upon her framework, showing a balance of constitutional rigor and respect for the court's authority. As she neared the end of her oral argument, Crockett returned to first principles. The Constitution's promise of equal protection means that when states choose to provide education, as all 50 have, they cannot do so in a way that systematically advantages some children and disadvantages others simply because of where they live. She declared, "This court has both the authority and the duty to enforce that principle while leaving room for lawmakers to shape specific educational policies." Her final words captured both moral conviction and deep constitutional understanding. "The framework I've presented allows this court to uphold its role as guardian of equal protection while preserving proper respect for legislative judgment. It aligns with the court's own precedents, honors federalism, and stays true to the Constitution's core promise, equality under the law." When she finished, a profound stillness filled the chamber, that rare kind of silence signaling extraordinary advocacy. Even seasoned attorneys waiting for their own cases had stopped reviewing notes, absorbed completely by what they had just witnessed. Then came the moment that would soon be discussed across the legal world. Instead of moving immediately to the next presenter, Chief Justice John Roberts leaned forward. His tone was steady but unusually personal. "Representative Crockett," he began, "before we move to questions, I want to acknowledge something. In my years on this court, I have rarely encountered legal reasoning that so clearly connects constitutional principles, preceded, and real-world impact. Your argument today represents advocacy at its finest." The courtroom went completely silent. Those familiar with Supreme Court proceedings knew how extraordinary this was. Chief Justices seldom interrupt to deliver direct praise, and Roberts, known for his measured temperament, did so only in the most exceptional circumstances. His words carried unmistakable sincerity. "Your ability to anticipate and address institutional concerns while maintaining a coherent constitutional framework," Roberts continued, "reflects the kind of rigorous thinking that strengthens this court's deliberations regardless of where individual justices may ultimately stand." This wasn't polite formality. It was genuine professional admiration. The Chief Justice's comments recognized intellectual integrity, precision, and the rare quality of argumentation that elevates the entire legal system. Justice Sonia Sotomayor, often on the opposite end of Roberts's judicial philosophy, nodded in agreement, a subtle but powerful sign of shared respect. Though their ideologies differed, Both recognized the brilliance of Crockett's reasoning. Roberts concluded with words that would echo beyond the courtroom. Advocacy of this caliber lifts the entire legal profession. It reminds us that the best legal argument is not about partisanship, but about a faithful, principled reading of the Constitution. The silence that followed was not one of surprise, but of reverence. Everyone in the chamber, justices, lawyers, and journalists alike, understood they had witnessed something rare and important. Even reporters, often focused on ideological battles, realized this exchange had transcended politics. After several seconds, Crockett responded with grace that matched the "Thank you, Mr. Chief Justice," she said. "Having the chance to present these constitutional questions before this court is the highest privilege in our profession. I'm deeply honored by your words." The brief exchange captured something timeless about true legal excellence that, beyond politics and disagreement, principled reasoning and professional integrity still command universal respect. Justice Stephen Breyer, known for his practical approach to constitutional questions, then leaned forward to build upon Crockett's framework rather than challenge it. "Representative Crockett," he said thoughtfully, "based on your reasoning, how would you suggest the court define the standard for determining when educational disparities cross the constitutional threshold?" His question wasn't a critique, but a continuation, clear evidence that Crockett's exceptional advocacy had shifted the entire tone of the discussion. The debate was no longer about whether her argument had merit, but how it might shape the future of constitutional law and education. The exchange between Chief Justice Roberts and Representative Jasmine Crockett marked a level of engagement usually reserved for the most compelling arguments, the kind that captures the attention of every justice regardless of prior leanings. Crockett's calm and precise response to Justice Stephen Breyer's question showed exactly why her advocacy had earned such respect. "Justice Breyer," she began, "I would define the standard by asking whether disparities effectively block children from receiving the foundational education necessary for exercising other constitutional rights and participating fully in civic life. This approach examines both resources and results using a practical, not purely formal lens." She went on to outline clear, workable criteria that courts could apply without intruding into legislative policy. Her framework acknowledged real concerns about judicial overreach while offering a principled guide for enforcing the Constitution's guarantees, a careful balance that impressed observers across the spectrum. It was exactly the kind of nuanced analysis that earns professional respect no matter one's political stance. As questioning continued, justices from every corner of the court, conservative, liberal, and moderate alike, engaged directly with Crockett's framework. Their questions didn't necessarily signal agreement, but demonstrated intellectual respect for her reasoning. They tested her logic, explored the limits of her theory, and examined its real-world applications. This kind of substantive back and forth was a sign that the court was treating her argument seriously on its merits, not its politics. Through it all, Crockett remained composed and analytical. She never grew defensive under tough questioning or triumphant when receiving supportive remarks. Each response showed discipline, respect, and depth, reinforcing the very qualities Roberts had praised. Her unwavering professionalism confirmed that this was more than a strong presentation. It was a model of legal advocacy at its finest. When her allotted time ended and the next attorney rose, something unusual occurred. Several justices, including some likely to disagree with her position, began jotting down notes, not just to prepare counterpoints, but to capture her analytical structure and phrasing. Even in the press section, journalists who had arrived, expecting another ideologically divided session, found themselves covering a moment that transcended those usual narratives. It was clear to everyone in the chamber that they had witnessed something rare, a display of professional excellence and mutual respect that reminded people why the Supreme Court remains one of the nation's most revered institutions. What neither Roberts nor Crockett could have foreseen was how rapidly this moment would spread beyond the courtroom. Within days, word of their exchange echoed across law schools, legal forums, and bar associations. What might have been a routine day of oral arguments had become a defining story about excellence in legal reasoning and the power of respect across ideological divides. When the official transcript and audio recording of the session were released. They circulated widely far beyond typical legal circles. Professors from top law schools, regardless of their political leanings, shared the argument with students. It wasn't used to promote a particular legal view, but as an example of extraordinary advocacy and professional integrity in my 30 years of teaching constitutional law, said one professor. I've rarely used oral arguments as direct teaching tools, but Crockett's presentation and Chief Justice Roberts' recognition of it offers something future lawyers must study. It's a reminder that great advocacy comes from clarity, preparation, and principle, not ideology. Major law firms also began incorporating the exchange into their professional development programs. A senior partner at a national firm explained, "What makes this so valuable isn't that Roberts and Crockett agreed. It's that both demonstrated what real legal excellence looks like. Anticipating counter-arguments, engaging respectfully with precedent, and building logically consistent frameworks. Those are the hallmarks of great lawyering." The impact reached well beyond classrooms and firms. Judicial conferences, bar associations, and continuing education seminars across the country began referencing the Roberts-Crockett exchange and discussions about excellence in advocacy. These conversations highlighted 3 lessons from Crockett's presentation: precision in defining constitutional questions, thoughtful engagement with challenging precedent, and deep respect for institutional roles while advancing principled arguments for both Roberts and Crockett. The national attention was unexpected but meaningful. When asked weeks later at a judicial conference, Roberts offered a measured reflection. The court functions best when presented with the strongest possible reasoning from every side. Recognizing exceptional advocacy isn't about agreement. It's about appreciating analysis that helps the court fulfill its constitutional mission. Crockett echoed that sentiment in a speech to students at her alma mater. "What matters most," she said, "isn't that my argument was recognized. It's that our legal system still has room for real engagement across philosophies and perspectives. The law at its best is about ideas, not ideology." The broader impact of their exchange soon became clear. In a time when coverage of the Supreme Court often focuses on partisanship, this moment reminded the nation that law and politics are not the same. Beneath the surface of ideological battles lies a legal tradition built on reason, discipline, and respect for constitutional principle. Even commentators who typically frame court decisions through political narratives shifted their focus. One respected constitutional scholar summed it up best. "What makes the Roberts-Crockett exchange so significant isn't mere courtesy between 2 accomplished professionals. It's the living proof that even in polarized times, legal craft, intellectual honesty, and principled reasoning still unite the profession." It was a powerful reminder that at its best, the Supreme Court operates not as a political arena, but as a legal institution grounded in reasoning, fairness, and principle. It showed how genuine legal excellence can earn respect from every side, regardless of ideology. 6 months after the Wilson arguments, as the legal community eagerly awaited the court's ruling, law schools across the nation organized a coordinated series of programs exploring what true excellence in legal reasoning looks like across divides. Judges, attorneys, and scholars from diverse judicial backgrounds gathered to discuss how Representative Jasmine Crockett's advocacy reflected the kind of thoughtful engagement that elevates the entire legal process. One federal judge summarized it best during one of these events. What Representative Crockett demonstrated wasn't advocacy designed only to please those who already agreed with her. It was advocacy that earned respect from those who didn't because it took their concerns seriously and addressed them with substance. This focus on substantive engagement rather than persuasion revealed a deeper understanding of what advocacy truly means in a constitutional democracy. A Sohn Distinguished Appellate Attorney put it, "The highest form of advocacy isn't about scoring rhetorical victories. It's about advancing understanding, helping courts and citizens alike grasp how constitutional principles apply in real life. True advocacy respects differing views while holding firmly to principle." Law clerks from that Supreme Court term later shared with proper discretion that Crockett's analytical framework had become a meaningful point of reference. During internal discussions among the justices without disclosing private deliberations, several clerks noted that her reasoning was cited repeatedly across ideological lines, even by justice who ultimately disagreed with her conclusions when the court finally issued its decision in Wilson v. Department of Education. Observers noticed something unusual. As expected, the justices differed on specific interpretations of the Equal Protection Clause. Yet parts of the opinion revealed shared analytical ground that reflected key elements of Crockett's framework. Chief Justice Roberts' majority opinion included a rare acknowledgement. While members of this court may reach different conclusions about specific applications of equal protection principles to educational funding, we recognize the exceptionally thoughtful framework presented during oral argument which helped clarify the constitutional questions at stake. This kind of explicit citation crediting an advocate's contribution to the court's reasoning was extraordinary. It confirmed how deeply Crockett's legal analysis had influenced the court's understanding of the issues, transcending political and philosophical divides. In the months that followed, law schools across the country began integrating the Roberts-Crockett exchange into their curricula. Instead of focusing solely on winning strategies or persuasive flair, professors emphasized how true advocacy strengthens the judicial process itself through rigorous reasoning, respect for precedent, and engagement across perspectives. A year later, a consortium of top law schools announced the launch of the Excellence in Constitutional Advocacy program, a new initiative designed to train future lawyers in the very qualities. Crockett had displayed precision in reasoning, substantive engagement with complex precedented and principled advocacy that earns respect across ideological lines. Invited to speak at the program's launch, Crockett used her remarks to refocus attention on the values that matter most in legal practice. Excellence in advocacy, she said, serves something far greater than any single case. Our constitutional system thrives when courts hear the strongest possible arguments from all sides. When advocates anticipate opposing concerns, address them honestly, and maintain analytical integrity, they help strengthen the foundations of our democracy. Chief Justice Roberts, while declining formal participation to preserve judicial neutrality, sent a message that echoed the same values. The quality of advocacy directly affects the quality of judicial decision-making. When advocates present rigorous, principled arguments that engage sincerely with differing views, they help the courts fulfill their constitutional purpose. The story of Roberts' recognition of Crockett's legal brilliance became more than a courtroom moment. It became a teaching example across the legal world. It showed that beneath the noise of political narratives, America's legal institutions still hold space for excellence, integrity, and principled reasoning. Their exchange stood as proof that substantive engagement across differences doesn't weaken the system, it strengthens it. It reminded lawyers, scholars, and citizens alike that the true measure of advocacy is not who wins, but how the argument advances understanding and respect for the Constitution. As we conclude this remarkable story, we invite viewers to like, share, and subscribe for more inspiring stories that celebrate excellence, integrity, and mutual respect in American public life. In a time when division often dominates headlines, we aim to highlight the professionals and institutions still proving that reason, respect, and rigor can transcend politics. America's legal challenges are complex, and perspectives on constitutional interpretation will always vary. But the Roberts-Crockett exchange reminds us that solving these challenges requires not just advocacy for a position, but the kind of deep reasoning and substantive dialogue that strengthen democracy itself. So ask yourself in your own professional journey, how might you apply the same lesson? How can you hold firm to your convictions while engaging honestly with different perspectives? The health of our democratic system depends on individuals in law, politics, and every field who can combine conviction with intellectual integrity and respect, just as Roberts and Crockett did in their extraordinary moment of shared excellence.